Hi, welcome back to the podcast HOA Hell. I'm your host, Michael Kushner, and with me is Sam Kill, Senior Associate at MBK Chapman. Sam, good morning.
Morning, Mike. How are you?
I'm fine, thank you. Sam, I think you'll agree that today's topic is a heavy one. Okay, so let me start by painting a couple of scenarios out for you before we to kick things off. Okay. Take a family next door has an 18-year-old with schizophrenia. Okay. And occasionally, this young man has fits of screaming, loud shouting, that sort of thing. Or down the street, take a family where you have an elderly spouse taking care of his wife who's got Alzheimer's. And occasionally, the wife gets out of the house and is seen walking down the street without clothes on, or will knock on a neighbor's door asking for help to get home. Doesn't remember where she lives.
Yeah.
Okay. Or take the 12-year-old across the street with diagnosed with Tourette's, and at times shouts and screams very, very disturbing things, profanity and other things that are very socially inappropriate. Okay. Or an alcoholic or a teenage girl with opioid addiction. Struggling with addiction and treatment. What do you do? So today we're going to address this heavy topic. We're going to talk about what happens when a homeowner has a family member with a mental illness and or other mental health issues, but we'll call it mental illness. Those are going to be interchangeable today.
Exigent circumstances. I mean, Unfortunately, we see these all the time. And from consultations to actual cases we've worked, these are not just theoretical issues.
Yeah. So that's what we're going to cover today. We're going to talk about these real life and for whatever reason, increasingly more common, probably because there's more HOAs.
Yeah.
Okay.
Proliferation of the HOAs and we see it
probably
more.
why.
Yeah.
But we're going to talk about the real life situation where mental health and HOA regulations kind of conflict and converge.
Yeah.
We're going to talk about ways that some bad HOAs engage in dealing with that, whether it's selective enforcement or failure to accommodate. We're going to talk about the laws that protect people suffering from mental illnesses. We're going to talk about what homeowners can do if their family member is facing that challenge. And we're going to talk about where the line is between a nuisance that's actionable and one that doesn't.
Right.
It falls under accommodations, right? So let's start with the mental health and housing protections. Sam, walk me through the two laws that govern here.
Well, we have, under the state laws, we have FEHA, which essentially affords homeowners and residents protections against discrimination in housing. We also have the federal counterparts of that under federal law that protects homeowners against the same exact thing.
So just to be clear for everybody, the federal law that he's talking about is the Fair Housing Act, is FHA.
Correct.
And the state law is FEHA, FEHA.
Yeah.
And it's the state counterpart, basically, Fair Employment and Housing. So Act. So that's where you get FEHA, but it's Fair Employment and Housing. So Fair Housing and Fair Employment and Housing for California, but we'll call it FHA and FEHA if we use that again, okay?
And we have agencies with the state, such as the DFEH under the California Civil Rights Department,
right? That
enforce these UNRWA rules, things of that nature.
That's right. So we have two sets of laws that govern simultaneously, federal and state, okay? And the reason for that, by the way, is because, especially the examples I gave today, Alzheimer's, schizophrenia, Tourette's, or even alcohol or drug use, if treatment is being done, are all protected under those laws because they are classified under the DSM, the Diagnostic Statistical Manual, as mental disabilities. Right. Okay? They're listed in that manual. And those conditions are therefore protected as disabilities, just like somebody with hearing impairment or vision impairment or somebody that uses a wheelchair. Just as those are protected, mental health and mental illness is also protected as well. And there is no difference in the eyes of the law between, let's say, being blind and needing accommodations and having schizophrenia or having Tourette's. Okay? So, with the law out of the way, let me start by talking about how harassment and selective enforcement arise.
Yeah.
Because that's by far the most common way that we see the intersection, the negative intersection between HOA governance and mental health. Okay? Homeowners with family members struggling with mental health conditions often encounter patterns that look a lot like some of the following, okay? Board labeling.
Yeah.
Okay? They will label you a nuisance. You know, maybe not right at first, but after, let's say, there's been multiple complaints about the son with the schizophrenia, let's say. The board will label them a nuisance, and anytime in the future something comes up, automatically a nuisance, you know, send a hearing letter. And they don't consider accommodations at that point. They're not even considering the mental health aspect. Okay, we see that sort of abuse, okay? Or pressure from neighbors. I'm sick and tired of having to hear that kid scream, you know, for 10 minutes every day. You know, I want you to do something, you know, and the pressure, you know, do something. That is the impetus for a lot of activity we see.
Sure, yeah.
Selective enforcement ends up becoming a byproduct of that because at that point, maybe you're more strict with that family. Maybe your level of tolerance is gone. And so at the first sign of trouble, bam.
Well, once you're deemed designated a chronic nuisance, essentially,
Right.
you know, they're being, in effect, targeted.
And it's understandable. Yeah. It's human nature. I understand where it's coming from.
Yeah. It's a difficult issue to navigate. And
For
what
both
a lot
sides.
of these lay volunteer board members fail to recognize is that it's so nuanced and it needs to be treated with care. And you can't just simply rigidly enforce and go with the complainant.
Because
on
we're
these
talking
issues.
about civil rights.
Yeah.
Okay. And the last one is kind of, he was leading to this, is public shaming.
Yeah.
There are duties of confidentiality that board members, for example, have to, as a matter of we talked yesterday, we talked in yesterday's podcast on fiduciary duty. They have a fiduciary duty to maintain those confidentialities. So if you have board members gossiping about things they heard in confidence about somebody's disabilities, the Tourette's or the schizophrenia, let's say that's not something that somebody wants generally known.
Yeah.
You got to make the board aware to get the accommodation, and we'll talk about that later in this episode. But you can't just go around talking to your friend, you know, hey, so yeah, we had the troublemaker in a hearing last week, and it turns out they've got the schizophrenia, and blah, or his daughter. This guy's daughter's addicted to opioids and is in treatment, and that's why she's had, you know, that's why that ambulance has come in the middle of the night 4 times and whatever. You can't do that.
Or refer to the entire household or house as a trouble house or problem house in an open meeting.
Yeah, exactly.
No.
Oh, we'll go ahead and hear from the problem house. Yeah. Yeah. You can't do that.
No.
Okay, the discipline is private. When we've talked in other episodes about discipline taken, you know, for true violations of rules where you're given notice of a hearing, et cetera, remember those hearings occur in executive session, which is private. It's the board and you and maybe a lawyer or the management company sometimes, but certainly not open meeting. So you can't take what's discussed there and throw it into open meeting. Yeah. So when you start labeling, you're violating an oath, okay? So that sort of abuse, the selective enforcement, the lack of confidentiality, the immediately labeling of nuisance, those are all forms of harassment, and the harassment is based directly on a known disability. In this case, a mental disability, a mental health issue, which is the same thing as refusing to allow a blind person to have their service animal. I mean, it's the same thing.
Yeah.
It's a big deal. It's a huge potential liability for the HOA. So let's talk about reasonable accommodations, because the obligation by the HOA in these scenarios is to provide reasonable accommodations. Now, I want to be clear about something, and we're going to talk about this. I'm sure I'll say this again later. HOA is not, just because somebody has a mental health diagnosis or has a mental health issue, schizophrenia or Tourette's or whatever, doesn't mean that that person gets to do whatever they want.
No.
That's not how it works. We still live in a society, and in this case, in a community, and health and safety are still paramount importance. So to the extent that the health and safety of other people is in jeopardy, the HOA can act, notwithstanding whatever you might have going on with you or your family member, okay? But at the same time, the law requires them to view that person differently And this is where accommodations come in. But the accommodation has to be requested by the family. I remember this article from an organization in California called ECHO.
Oh, yeah.
I can't remember what it stands for, but the article is entitled Mental Illness and Aberrant Behavior in HOAs. And it went through and discussed pretty concisely the struggle between the business judgment rule and the requirement the HOA, take care of the health and safety of residents versus the federal laws out there requiring reasonable accommodations for mental illness and stuff like that. And it was actually a pretty good article on the topic. And that's that interplay between enforcing governing documents, making sure health and safety are followed, making sure that there aren't, nuisances jeopardizing reasonable quiet enjoyment versus compliance with reasonable accommodation requirements under federal and state law. That interplay is the rub. The devil's in those details.
It really is. And on this issue specifically, that interplay and that twilight between those two competing forces oftentimes even enhances the need for some sophisticated guidance by good HOA attorneys, let's say, or experienced management even helping out with some ideas and some creative thinking outside the box.
And that's where some of the some of the larger, more experienced management companies come into play. There are a few that represent, dozens, hundreds, even thousands of HOAs across the country. They're the ones that tend to be a little bit more experienced in this sort of thing. But certainly any HOA attorney on the HOA side, the other side of us, would be experienced in this and being able to advise their board. But when a homeowner with a mentally ill family member requests an accommodation, under federal and state law, the board is obligated to investigate whether or not an accommodation is possible, and if so, to grant that. Okay, so we're going to talk about that. Let me give you an example. It might one example might be allowing additional time to respond to complaints about behavior if it's connected to a mental health condition, okay? Or delivering notices and communications in a respectful manner as opposed to having the HOA lawyer write a typical demand letter that is extremely draconian and accusatory, maybe a little bit more sensitively, okay? Training management or whoever is doing walkarounds to enforce.
The interface too,
Right, that interface to be a little bit more sensitive such that to not treat mental health disclosures as a subject of gossip, as a proper subject of gossip.
Right.
To have some confidentiality.
And by the way, just a quick note here, Mike, that's not equal to favoritism or selective enforcement, and the opposite, as in you are giving them something extra. In this case, it's warranted because it's part of that extra care that is required by law, essentially.
The confidentiality, yeah. Absolutely.
Yeah.
So, and here's one that really matters. This is the most important one. And that is the modifying enforcement approaches to account for treatment or therapy schedules. Let me give you an example, okay? In the case of the 18-year-old with the schizophrenia that we've talked about, a possible accommodation to request might be extending time frames for responding to noise complaints while the family pursues medical or therapeutic interventions. Or it could mean working with the family on agreed quiet hours, compliance plans, or allowing the family to install additional soundproofing modifications and the HOA agreeing to fast track their review and approval of those modifications. Each of those could be an accommodation, okay? Or let's take this for example. Let's take the case of the Alzheimer's sufferer, okay? A possible accommodation would be to give the caregiver or spouse, right, the one that was taking care of the one with Alzheimer's, advance notice before issuing a violation or offering flexibility in enforcement, maybe altering the dress code in that person's case, right? Or, somehow modifying their whatever the community's public decency rules are, if there are any, okay? Or the accommodation can include cooperating on environmental adjustments, fencing, lighting, or signage maybe even in the common area to help.
That can be huge.
Steer that person back if they get lost. Or, and this is just being creative, it could be something as out of the box as maybe training some of the neighbors in how to respond if she comes knocking on the door, or even giving them some phone numbers to call. And of course, you would have to do that with the permission of the family as an accommodation because you can't go to the neighbors and disclose confidential information. But that would be an example of that. Let me give you one more. Let's talk about the 12-year-old because this is an important one. The 12-year-old with schizophrenia. I'm sorry, the 12-year-old with Tourette's. Well, the fact is, it doesn't matter. I don't even see the issue of an accommodation here. When it comes to Tourette's, there's nothing an HOA is going to be able to do to ever issue a nuisance claim. If the Tourette's is verbal, okay, screaming and shouting improper things, there's nothing the HOA can do. Let me give you an example as to why. And this is a strong belief on my part. There isn't a direct case on that, but from 30 years experience, that's my opinion on this. In the case of the Alzheimer's patient, in the case of the alcoholic, in the case of the schizophrenia, if the person getting out, the person being heard, getting out in the community naked or knocking on doors is understandable, but it is a failure on the part of the people watching that person.
Yep. And
there are things they can do. They can modify the locking system in the house so the person can't get out without help. Like you would with a child, right? In the case of Tourette's, there's nothing that can be done to stop these outbursts. The brain those tics, and they are tics, will occur. And they can't be accommodated in the sense that there's nothing that anybody can do to stop it. You can't make the kid, all right, you have to stay in a soundproof room for your life. That's not reasonable or fair. It certainly wouldn't be legal under any equal protection law, right? So there's nothing, it's not a failure on anybody's part. It just is what it is. Now, if Tourette's, and it doesn't, but if Tourette's were to manifest in a way that made somebody dangerous,
that's different.
That would be different, but that's not how it works. By definition, Tourette's will either manifest in tics that are quiet and therefore nobody's business, or in screaming out words or phrases that may or may not be appropriate. And to the extent that it's the latter, it's never going to be a nuisance because it will, by definition, fall under that mental illness. And there isn't an accommodation that could be granted other than, guys, you got to live with it. Yep. This is not a violation we can punish these people for. So that's a unique situation in the examples I gave. Okay. But even I'm loath to talk about the drug and alcohol one because it's kind of complicated because it only applies, these accommodation requirements only apply if there's actual treatment being sought, right? If a person is an alcoholic or a drug user and is not seeking treatment, they don't even fall under the protections. And those are complicated and I don't want to get into those.
Very case-by-case basis.
We might do that on a separate podcast where we just deal with that issue because it is alcoholism and opioids and drug use that does cause nuisances and things is a big issue because it can lead to other crimes as well and people coming into the neighborhood that you might not want. There's a whole
or
Pandora's box.
Meth homes, illicit conduct.
Right.
All that
so
stuff.
that's something we'll probably do at another. That's why I'm not giving an example of an accommodation for that. I think we'll do that in another episode. But the bottom line is reasonable accommodations are required. That doesn't mean that the HOA is obligated to allow dangerous conduct. Okay, that's never the case. To the extent that the conduct it can risk the health and safety of other people, that's never going to be allowed. But in the case of Tourette's, for example, if the worst thing is it is a nuisance, so if anybody else were saying the same things at the same volume, it might very well constitute a nuisance. In the case of that 12-year-old with Tourette's, it will not constitute a nuisance. Okay? Now, let's talk about, and you're going to help me a little more here, Sam, where boards most often cross the line. Okay? I'll start us off. Boards often cross the line when they treat as nuisances, automatic nuisance claims. They issue hearings for fines and treat mental illness issues automatically as nuisances.
Right.
Instead of seeing it through the lens of a mental illness.
Right.
And the whole whether or not accommodations could help and what accommodations could and what could we do to help alleviate that situation.
That's right.
Okay?
Yeah. Well, another one is they refuse to engage in accommodations. I mean, you kind of touched on it.
Right. So what does that mean?
Working with them in a creative sense. In some cases, Mike, and I know you and I briefly discussed this
So
earlier.
let me paint a scenario.
Yeah,
and
go
then you
for it.
tell me if
Yeah.
I have a mentally ill son and I approach my board and say, look, he's been screaming. I know it's bugging the neighbor. You might have even gotten some complaints. I'd like to talk to you guys. I want to meet with you in executive session and talk about an accommodation. And they say, no, you need to shut your kid up. Talk to me.
Well, first off, you can't do that. I mean, and also depending on how you present that, if you do it as a way of an IDR, you're entitled to it, and they're obligated to meet with you. Okay, by the way, we covered this extensively in other podcasts we did. And in this case, it would also be tantamount to them breaching their duty of care, their fiduciary duties, to actually work with you, to investigate the matter, to look for solutions. And what they can do is when you make that request for what to me that would constitute in your scenario is a request for reasonable accommodation, and they're supposed to kind of probe into that. And there's a interactive process essentially where they can talk to you, question, answer. They can't probe too intrusively into the various medical
But
details.
you used a term now that I didn't use, and it's actually exactly the term used in the law, and that's
interactive process.
Interactive process.
Yeah,
That's
so they
very
can do
good.
that. Yeah.
They have to engage in an interactive process with you to look for a solution, if one can be had, that will address the mental health issue and hopefully alleviate some of the...
They can't be cavalier about it. They can't abdicate that element. They have an absolute duty to do it, and failing to do so by these boards would open them to exposure of risk of liability.
Exactly.
Yeah.
Okay. Another one is we see this happen a lot. Again, human nature. Everybody loves to gossip.
Yeah.
Everybody loves to tell stories. We were at lunch yesterday and we were doing a little bit of gossip. Of course, it was interpersonal stuff, but we were engaging in a little bit of fun gossip. But that's a very common issue. Mm-hmm. You hear a juicy story or a juicy tidbit of information and you can't wait to share it with somebody. Mm-hmm. That's universal, folks. It is. Yeah. But in the case of a board member who has knowledge of something mental health related that was given in confidence, and certainly this would have been, and then shares that with somebody that's not in the know, not the lawyer, not the management company, not other members of the board, but just members at large, illegal. Can't do it. That is a violation of the law, a violation of fiduciary duty, and we see it all the time. Can't do it. Got to resist that. Okay?
It's highly sensitive information, so you're entrusted with that.
Right.
You better keep it protected.
You need to keep it. And that includes when you're not on the board anymore. So next, I think let's talk about practical steps for homeowners, okay? Yep. If you're a homeowner facing harassment due to mental illness of yourself or a family member, obviously I want you to document everything.
Yeah.
Okay? Keep copies of everything. Letters, emails, requests, notices, even logs, log incidents. Okay? Log when something occurred and there was a reaction to it. Okay? Requested accommodation in writing.
That's very important. Yeah.
You have to explain, my son, my daughter, I have Tourette's or Alzheimer's or this. You don't have to go into detail about how long you've suffered from it and what medications you're on and, are you in therapy? None of that. But you've got to describe the disability because they have to know what their obligations are legally. Yeah. So you've got to do that. And they have to give them enough information to help you craft an accommodation.
Exactly.
Okay? So, you even want to suggest in requesting the accommodation what changes in nuisance standard you might be seeking. I know that we have a standard regarding noise after a certain time, but when due to the nature of my son's condition, when it's time for bed, he has a tantrum and it's allowed and it lasts about a half hour. We're going to need that extended by a half hour. You know what I mean?
Yeah.
It's just the way it is. That would be an example.
And I think that's a good way of framing it, where you acknowledge the rules and you understand them, you're cognizant of them,
right.
Yet you are asking for an accommodation so that they don't just kind of regurgitate the same rules back to you.
Yeah, we know what the rules are. We're saying, here's why the rule doesn't work for us because of our mine or my son's or my daughter's medical condition, right? You want to keep the medical details limited because, again, preserve your privacy. It's not their business. You shouldn't be obligated to expose all your secrets and things that can be embarrassing, even though they shouldn't be, okay? Or because human nature and you don't feel like it's anybody's business. And the law doesn't expect you to open up your entire life.
And there's a lot of room for abuse, so you just want to minimize that.
Exactly. Yeah. If necessary, you want to escalate through IDR or ADR.
Yeah.
And ADR being a higher threshold of escalation. That's under the Davis-Sterling Act, and that's where you'd get a lawyer like us, okay? And at any stage, at any point along this, if you feel, I just want help, you can come. This is when you would come to us and hire us to help you.
And there's really no bright line rule when it comes to guidance and working with someone to kind of help you navigate that process.
No. The issue of mental illness, HOA communities, is a very sensitive one. It involves loved ones. It involves a lot of just really heavy sometimes heartbreaking, sad, or expensive, just whatever. Stressful, it doesn't matter. The fact is it's a lot to deal with. And there's reasonableness on both sides. If you are a neighbor who has to hear the noise, especially if you're not aware of the situation, it might be easier to take if you were aware. You know, it requires understanding on both sides.
Yeah.
But when it comes to the HOA, they have to do certain things. They have to accommodate. They cannot treat somebody with a mental illness as just a member at large. Now, they don't have to allow a dangerous condition to exist, but they do have to take every step up to that to work with the family to come up with a solution, okay? Because people with mental illnesses deserve to live amongst us. They deserve to live in our communities. That's where they are.
Yeah.
It happens to people of all ages and genders and walks of life. So you got to work with them, okay? And a lot of this can be accomplished through just being a good human being.
Yeah.
But to the extent that dealing with people that don't want to engage there, the law does put some limits, and that's kind of what we're talking about today.
Yeah.
If you like this episode, please hit the like button. And if you haven't already done so, we sure would appreciate it if you would hit the subscribe button and subscribe to our channel. If you want to ask a question, leave a comment, or if you have yourself or a family member suffering from a mental illness and you want some advice, feel free to reach out to us. We'd love to hear from you. Until next time, have a wonderful day.